All right, good afternoon, ladies and gentlemen. Is the mic on? Can you guys hear me? I don't really need a mic anyway. My voice is, oh, there it is. All right. Welcome, ladies and gentlemen. On behalf of the American Enterprise Institute, it's my pleasure to welcome you to our discussion of patent reform in 2017. My name is Michael Rosen. I am a visiting scholar at AEI's Center for Internet Communications and Technology Policy. And it's my great privilege today to moderate the panel of such distinguished guests and speakers we have up here, whom I will introduce in just a moment. First, though, I'd like to thank Sarah Watson, Matt Au, and Kavya Ramesh for putting a lot of hard work into pulling this event together. So thank you very much, guys, for all your hard work. Now, ladies and gentlemen, it goes without saying that change is in the air. And whether that change will prove to be for ill or for good, nobody yet knows. I think some Americans are very excited about the change that's coming. Others are disappointed and anxious, all of which are natural feelings. And here at AEI, we've been carefully monitoring the change, but as many of you know, the Institute doesn't scrupulously avoid taking any public stance on the change. And of course, the change I'm talking about is the decision by Dean Spanos, the owner of the San Diego Chargers, to relocate my favorite football team to Los Angeles. But we'll set that aside. Today, we're going to discuss patent reform instead. So, in seriousness, how the new Congress and the incoming Trump administration are going to relate to patent issues is really an honest-to-God wild card, as I think we'll see in our discussion today. Given all the hot-button items on the Trump administration's agenda, it seems that intellectual property is fairly low on the list, but you really never know. And to put this in context, we've been holding these events about once a year for the last 4 years, and I can't recall any panel where there's been such uncertainty as to what exactly is going to happen in the coming year, the coming 4 years, or who knows what. So there are a lot of issues, but nobody really has a great handle on what's going on, and hopefully today we can bring some clarity to that. Now, adding to that uncertainty is the progress, or rather the lack of progress, on patent issues in the recent Congress, the last Congress, irrespective of Trump. 2016 was one of the quietest years in recent memory on the legislative front for patent issues. There were just a few minor bills that were introduced, none of which really gained any traction, all of which died when the Congress was finished. Really what ended up happening is the election year effect proved to be very strong, and as everyone expected it would. Now, that's not to say that nothing has happened on the patent front since we last convened about a year plus ago. Since that time, the Supreme Court has handed down some important decisions on willful infringement and design patents. Patent office trials have continued to evolve in certain important ways. There have even been some investors who've tried to use those patent office trials to profit. So it's not that there's been a shortage of interesting things to talk about. It's just that there's so much uncertainty as to where those issues are, how those issues are going to resolve themselves. So today, our job is to try to bring some structure to this discussion and to orient you as to where things may or may not be going. And to that end, it's my great pleasure to introduce our esteemed panel. Their complete biographies are available on the event website. And by the way, this event is being recorded, video recorded, and the entire stream should be available shortly after the event, maybe a couple days after. So anyway, our panelists' biographies are available on the website, but let me just provide a few highlights. To my immediate right is Ellen Schrantz, the Senior Director of Government Affairs and Counsel at the Internet Association, which represents 41 of the world's leading technology companies. Ellen previously served as counsel to Representative Darrell Issa, my own native San Diego, who is the chairman of the Subcommittee of Courts, Intellectual Property, and the Internet. Welcome, Ellen. To Ellen's right is Dr. Hans Sauer, the Deputy General Counsel of Intellectual Property for the Biotechnology Innovation Organization, which represents more than 1,100 biotech companies. Hans previously served in patent counsel roles for MGI Pharma and Guilford Pharmaceuticals. He holds a PhD in neuroscience from the University of Lund, and he currently serves as adjunct professor of law at the Georgetown University Law Center. Welcome, Hans. To Hans's right is Dr. Karen Norton, the Vice President and Senior Counsel at the Washington IP and Public Policy Office of Samsung Electronics America. Karen previously served as an investigative attorney for the Office of Unfair Import Investigations at the U.S. International Trade Commission, and she holds a PhD in human physiology. Welcome, Karen. And last but not least, Lori Self, the Vice President and Counsel of Government Affairs at Qualcomm, where she focuses on intellectual property and related policy matters. Lori was previously a partner at Covington & Burling, where she chaired the firm's intellectual property practice group. Welcome, Lori. Great to have you back again. All right, and with that, we'll jump right into our questions. So I'm going to start with, this is a question for everyone. We'll start with Ellen. What would you say, Ellen, are the 3 most important changes we should make to the patent system?
Well, I'll start with one I think we'll come back to quite a bit today, and that's venue reform. So making sure that the patent in question and the district handling the question are related. The Eastern District of Texas in particular has been of concern, I think, to many folks for years now, and we have action going on at the Supreme Court on that, which is exciting, and we have interest in Congress as well. And then after that, I would say the most important issues are related to patent quality and making sure that the Patent Office is able to move forward and continue implementing programs that really enhance patent quality. The root for patent abuse for us is low quality patents, and so the 2 items that I'll give there are clarity of the record in particular has been a big focus there, as well as programs like the post-grant pilot that they've launched. And so under Director Lee, they've taken enormous strides with the Enhancing Patent Quality Initiative, which has done so much in this area. And so continuing on those programs, I think, will be really key.
Great, thank you. Hans?
Well, I feel my thunder has been stolen. I also was going to start on patent quality. I think you're right. What I hear often from biomember companies is that there's probably a need going forward to increase measures that bolster confidence in the patent system as a whole, both for businesses to be able to rely on their IP for investment and for partnering for access to capital. And a robust patent quality, I think, is at the basis of that. Patent quality means a lot of different things to a lot of different people. I will certainly concur that clarity of the record, clarity of claim scope are the areas where the Patent Office can and is making the most immediate strides and where the most immediate gains can be made. I think these are worthwhile pursuits on which the PTO is on the right track. So quality, yes. Additional measures to increase confidence. It won't surprise you that from BIO's perspective, PTAB proceedings are perceived, the way they're unfolding, are perceived as injecting an astonishing amount of uncertainty in a system that was really designed to foster reliance and dependency on robust rights. So PTAB proceedings, from our perspective, are in need of tweaking and of modification to make them more balanced. Another thing that I often hear from biomember companies is greater clarity on the scope of patent-eligible subject matter, where we think the jurisprudence has been very unstable, and it's become a very robust but versatile tool to do a lot of things for a lot of different people who defend patent cases. It's the new multi-tool, a Swiss Army tool, if you will, for patent invalidation. So I think that too deserves clarification. So these would be my top 3.
Great, thanks. And we'll get into all of these in more detail, but it's just trying to orient ourselves and get a sense of that. So Karen, how about you?
I think we have unanimity on the panel here. I would say that patent quality is a key issue. Certainly to the extent that we can solve the problem at the outset, that will take care of many of the things that we complain about in litigation later on. The clarity of patents leads to greater confidence, leads to better business decisions in terms of what to do with a patent once you have been served with a suit or once you get notice of the patent. So I agree with my other panelists that the patent quality is key, and the measures that have been put in place at the Patent Office certainly should be given an opportunity to flourish and try to correct the problem at its start. One other area that I feel is often overlooked in the patent reform discussion is the International Trade Commission. And last year in 2016, there actually was an ITC reform bill introduced by Representatives Cardenas and Farenthold, the Trade Protection, Not Troll Protection Act of 2016. And essentially, there are three major areas of reform in that package. The first one being a modification to the domestic industry requirement. In the International Trade Commission, as opposed to district court, there's an additional requirement that the patentee have domestic investment in the United States. And we've been seeing some games being played with the domestic industry requirement, whereby a patentee will rely on a third party for their domestic industry requirement, and where the third party has nothing to do with the patent, doesn't want anything to do with the patentee, and certainly does not want to be dragged into a very expensive proceeding at the ITC. The second area has to do with the public interest analysis at the ITC. As it currently stands, the statute reads that the ITC will issue an exclusion order unless it finds that the public interest precludes an exclusion order. And the last time that that happened was in the mid-1980s. So this bill endeavors to broaden the considerations that the ITC takes into account in whether an exclusion order would issue, and also puts the onus on the ITC to determine that exclusion actually would serve the public interest. And the third part of the package is simply to codify a pilot proceeding that has been going on at the ITC, which is called the 100-day proceeding. And we can talk more about that as the day goes on.
Great. And just to be clear, you favor that package that was introduced, or at least
Yes.
the general thrust of it.
Mm-hmm.
Okay, great. Lori, how about you?
So putting aside the ITC issue, I think there is unanimity in the sense that we really need to focus on what I will describe as the kind of front-end issues, making sure that the PTO has the resources it needs, the technical training, appropriate guidance, particularly with respect to issues like Section 101 patent subject matter eligibility, to ensure that patents being reviewed are appropriately examined, and that the patents that are issued meet the statutory criteria as well as the 101 criteria. I would also agree wholeheartedly with Hans's comments about the destabilizing effect of what the 101 decisions, in particular in the Supreme Court, but the fact that over the past decade, you have had an incredible amount of change in the patent system. And so rather than kind of echoing what everybody has said, I would provide maybe more of a broad brush comment to say that I think over the last decade, there's been an enormous amount of focus on issues around patent litigation, and not to suggest that those aren't important, but I think it's also important to take a longer term perspective on the importance of our patent system, the importance of a strong, certain, stable patent system that does incentivize long-term investments in high-risk R&D, the kind of investments that Qualcomm and Samsung and others make. It's imperative that we as a country have policies that promote strong, predictable patent rights, and that we that we articulate those policies internationally. Historically, we have been, the standard bearer, the gold standard, however you want to characterize it, in terms of encouraging our trading partners to adhere to very high standards of intellectual property protection. I feel like we've lost some of that high ground, if you will, in recent years, and I think we need to restore that very strong message and commitment to intellectual property rights.
Great. Good. Well, I think that helps set the table nicely. But before we get into those in particular, I want to kind of take the flip side of that question, and we'll start with Hans on this one. What would you say are the 3 most important things that we should avoid doing in order to keep the system strong and effective as it is?
Well, I would start perhaps by saying we should avoid overcorrection. I think there can be no doubt really that compared to 10 years ago, today those who defend patent lawsuits as accused infringers have a lot more leverage in patent lawsuits than they had 10 years ago. Well, and that's a result of, I think, in part of what Laurie was describing, I think a trajectory in the judiciary to, I think, tilt the balance in ways that do provide more leverage to accused infringers. So in other words, accused infringers have it good today, certainly compared to 10 years ago. We should think, in the words of former Chief Judge Michel, whose words I'm going to make my own in this case, Judge Michel said, there's been too much patent reform too quickly, right? And there are persistent calls for more patent reform, bigger reforms, faster, while the system is still reeling from trying to absorb the last big changes. So overcorrection and the high speed at which efforts are being driven, I think ought to be something that we ought to take into account, that we should think about. We need to reflect about what we're doing. Patent reform going forward, I think, ought to be incremental. It's really important. So overcorrection is something to be avoided. I think we should find ways to not let the judiciary set very broad principles of trade and innovation policy in this country. This is for Congress to own, and sometimes Congress acts slowly. The AIA took 3 Congresses or more to pass. I think the next big bill will take 3 or more Congresses to pass, and that's by design. The Supreme Court, in our view, has had a tendency to take on big questions in the absence of congressional action and decide those without flinching about what it does to established business practices or established business expectations. That we see that in the 101 space. I think we're about to see it on the question of patent exhaustion, right, where hundreds of thousands of businesses have ordered their expectations and their businesses around their understanding of the law, and the Supreme Court might very well change and undo this. Right? So the role of the judiciary in setting patent policy and innovation policy and trade policy is something we ought to think about. Finally, we should avoid persevering and pushing reform ideas that are 4 or 5 years old. Things change. The Supreme Court does take questions off the table every now and then. So as we look at this coming Congress, for example, and at patent litigation reform bills that might be reintroduced, whether in whole cloth or in modular form, we should scrutinize these bills and see to which extent they include stale ideas that might have been relevant 2 Congresses ago, but ought not to be relevant today.
Great. Thank you, Hans. Ellen, what do you think?
Sure. Well, now is where I think it gets interesting, because what I actually wrote down for this is we should avoid weakening subject matter eligibility standards in kind of the post-Alice world. So what we've seen, particularly in the courts since the Alice decision 2 years ago, a little over 2 years ago, is that they're perfecting that decision and that test. That Alice didn't eliminate software patents by any means, and I won't say every decision has given the best, most perfect answer, but what we've seen from the court is that they're perfecting the test, they're showing what's patentable and what's not, what is an abstract idea, what is not allowed, and the Patent Office has been issuing guidance and revising their guidance to examiners. And so I think it would be very premature to try to legislatively or otherwise take the job away from the courts when they're doing their job. For us, Alice was a step forward in subject matter eligibility, and so we would, our companies would be very concerned to see action in that space when the courts are coming down with a lot of decisions in that area that clarify the post-Alice 101 world. The other two items that I had written down, interestingly, were to avoid weakening PTAB proceedings and post-grant review. In particular, I know claim interpretation and evidence standards have been big issues in the past, and so that has been an incredible tool for innovators and for startups across the country to remove weak patents, lower quality patents from the system that should not have been issued in the first place. And so to weaken that or to remove from PTAB some of the tools that have been most useful since the AIA, we have deep concerns about. And I think what's interesting about having the discussion about PTAB now versus 3 years ago, 4 years ago, is that we have a lot of statistics. We have a lot of evidence now in how PTAB proceedings are working. And what we've seen, and I know we'll get into this a little later, is that PTAB is doing its job, and it's doing its job really well. The courts who have reviewed appealed PTAB decisions are finding that they're issuing high-quality opinions, and that in fact the standards that they're using and the regulations that have been issued by and large are correct and are right for PTAB, this body of experts. And so taking away those tools would kind of dull the blade against low-quality patents that it seems we all agree are at the root of any problems in the system.
All right, thanks, Ellen. Lori, why don't we turn to you if you have some thoughts? What should we keep?
What should we not do, or
what should we not do?
Okay.
How should we keep things as they are?
Okay, so I would differ over the characterization of the PTAB proceedings, but what we should not do is create a patent system that favors the large over the small. What we should not do is create a patent system that is so complex, fraught with risk, fraught with the potential for having a patent invalidated years after you go through the process of getting it issued, such that startups can no longer survive in our economy. And to Hans's earlier point about overcorrection, I worry that some of the changes that have been taking place in the patent system have created such unpredictability, instability, complexity, which always carries increased cost, that it's making it increasingly difficult for startups. And again, I think it's important to differentiate among different business models, because some of the differences in perspective that you'll hear really at root are reflective of different business models and how different business models utilize patents or utilize patented technologies. So for Qualcomm, the company the startup that we were 30 years ago, patents were critically important to us in terms of our ability to justify big investments in R&D and to attract venture capital. And that same dynamic exists today. For many research-intensive startups, patents are critically important in terms of their ability to not only get off the ground, but to continue to attract repeat series of funding. And what we hear within the startup community increasingly, and again, we do talk to the startup community about how will this particular legislative change impact you, because that's kind of the barometer we use to measure whether a change is in fact productive or potentially counterproductive. But what we hear from a lot of research-intensive startups is that patents have become so uncertain and unreliable in the United States that it's become very difficult to attract venture capital, and that other countries are actually a more hospitable environment for research-intensive startups in the United States. To me, that is a really troubling dynamic. And again, you can argue that's primarily anecdotal. Different startups have different perspectives, but that is something that very much concerns me. I think historically, the genius of the US patent system was its highly democratic foundation, that all individuals, all inventors should have access to property rights via patents. And I worry that that foundation is increasingly under attack.
Thanks. Karen, I'm going to ask you, if you don't mind, to react to some of what Hans said. In particular, do you agree with Hans that accused infringers now have it easier than they've had it in a long time?
No, certainly that has not been my experience. And also, being in the tech community, we also face, perhaps more than in the bio community, we face the issues of patent assertion entities and non-practicing entities, many of whom use the cost of litigation in order to try to force settlements on patents which are increasingly subject to dispute and of dubious quality. So once again, I would say that I agree in large part with all of the entirety of this panel, that I think that all of us want a patent system which is a strong patent system and is a sound patent system. But I think that the basis of that sound, strong patent system are, again, high-quality patents. And the thing that I would say that we should not do is we should not allow the shifting sands of political whim completely disrupt that system. As we have talked about, Michelle Lee has done, in my opinion, a great job at trying to bring attention to the issues of patent quality and try to get a handle on patent quality to improve this system at the outset. And once again, I think that an improvement in the patent quality at the outset is going to take care of a lot of the problems that we're talking about. And certainly from a startup or small business point of view, I think that the current system has cut both ways. So on the one hand, one could say that their patent assets perhaps are seen to be worth less because of the uncertainty. At the same time, there's also been the studies that have shown that for a small company or a startup company, once they are threatened with a lawsuit, primarily from these NPEs or PAEs, venture capital dries up, their research and development plummets, and we run into another problem with innovation in the startup and small business space.
So let's turn to that then, and let's discuss the problem of patent abuse. And I want to get a sense from all of you as to how serious you view this problem as being. And without getting into the definitions of trolls, PAEs, NPEs, which we can have angels dancing on the head of a pin. Ellen, maybe we'll start with you. What are your thoughts on how serious this problem is, and what is the problem? What actually is it?
Sure. Well, I'll start off by saying yes, it is a problem. It is a continuing problem, and whatever we call NPEs, PAEs, however we define it, statistics still show that we do in fact have a problem with abusive patent litigation, as well as making sure that we have resources to improve the quality of patents, like at PTAB. And I know that there have been a lot of recent numbers that have come out on 2016, and happy to discuss those if that's of interest to everybody. But I think what's interesting about those numbers is not just the overall numbers, it's a question of how many of those cases are high volume filers, where are they filing their lawsuits, and who are they filing their lawsuits against. And so when you look at it in that light, you're seeing, yes, there are still high volume filers, which tend to be non-practicing entities and others. We're still seeing a highly disproportionate number of cases in the Eastern District of Texas. And we're seeing, interestingly, a shift from just fighting the biggest and largest who are now saying we will fight every NPE, PAE, whoever it is that takes us to court, and attention on the little guy who's not going to have the resources to necessarily fight in district court or fly all the way down to Marshall, Texas and have it out there. And so is it still a problem? Absolutely. And so I would say to folks looking at the numbers, break those numbers down and you'll see that yes, it absolutely is still persistent. And what we're seeing on not just the litigation side, but the quality side is absolutely, when you look at what PTAB is doing and the affirmation of the decisions they're making, they are weeding out low quality patents from the system. And they're doing a very good job of issuing quality opinions when you look at the appeals. And so we still have a lot to go there. We're making a lot of progress, but I don't think the job is done yet.
Okay. Hans?
So you started asking, well, you know, how big a problem is abuse and what is its root cause, right? I think no system, the patent system, I don't think ever was truly immune from abuse. If we look at the current narrative that's been developed over, I would say about the past 10 years, right? I do find that there is a lot of emphasis on the kinds of entities who assert patents and very little discussion about infringing activities or what it really means to have a bad or a good patent. There are a lot of patents out in the marketplace where today we would say those are bad patents, which were perfectly good 10, 15 years ago when they were issued, but which became bad due to intervening changes in the law. Just declaring a patent to be bad, you know, doesn't necessarily make it so. It becomes bad for present purposes. But when patents today are reviewed under standards that are different from the standards that applied when the patent was first examined and granted, you know, that's akin to changing the rules midway. And it doesn't help patentees being told you now have a bad patent for reasons that you couldn't have foreseen 10, 15 years ago when you prosecuted the patent. If we look at the PTAB and its invalidation rates, right? So we have here a system, a new system, where patents go into proceedings under no presumption of validity, under no presumption that the original grant of the patent was administratively correct, using lower standards of proof than those that traditionally applied in district court, using claim constructions that are frankly more amenable to invalidation. In a proceeding where there's no meaningful opportunity to amend the claims, and in a proceeding that can be brought multiple times against the same patent. Right? That proceeding produces invalidation rates of upwards of 70% of all patents that go into these proceedings. Does that mean that 70% of all patents are bad? I don't know. But I think these invalidation rates tell us at least as much about the proceeding than they do about the patents that go into these proceedings. It is often said that these high invalidation rates are produced because the proceeding is enriched for bad patents, low-hanging fruit. We've heard that. I don't think that's the case. I think these proceedings are enriched for important patents, because 80% of all patents that go into these PTAB proceedings are in district court litigation, which tells us that somebody cares about them. Right, so at the end of the day, I think there are like very big questions to ask right now. This is one aspect of what I meant, where the leverage really has changed for the benefit of infringers. There are signs of abuse. I think abusers are often symptoms, not the cause of the problem. To give you an example of abuse at the PTAB are entities that produce no products, that don't compete with the patentee, that produce nothing really. They're financial speculators that bring almost 1 out of 5 IPRs in the life sciences space are brought by hedge funds or other financial speculators. Our companies view that too as a problem. It's been described as reverse trawling. So yes, you know, we're going to be the last to say that the system is free of abuse and free of problems. What we do need, though, is balance. The remedy for all these problems can't be to boost like the power of incumbents and large corporations. I very much agree with Laurie that the changes we're seeing in the system, as the changes that were brought by the AIA, have large corporate fingerprints on them, and they tend to favor bigger corporations with deeper pockets.
All right, thanks, Hans. Now we're getting somewhere. Karen, And let me. Well, first of all, as a representative of a large corporation with deep pockets, can you share your thoughts on that as well? But for both you and Lori, in addition to reflecting on how big the problem is, what's your sense as to whether existing court decisions, AIA regulations, other guidelines, how well a job are they doing right now without further legislation of rooting out that problem? So, Karen.
Well, I would like to begin by talking a little bit about the statistics that Hans gave. And I think that the first thing that I would take issue with is saying that over 70% of patents are invalidated in PTAB. That is true if you only look at the patents which were actually instituted in PTAB. And one of the analogies that I've often used to describe that process is it's also true that more people who have been indicted actually go to prison than people that you randomly pick off the street. Because if you have a patent, you are free to go to district court. And there will be a defense. And whether the patent is good or the patent is bad, there will still be a defense. And you will go through the trial and you will get a decision one way or the other. On the other hand, when it comes to the PTAB and IPR, there is a gatekeeper before you even get into, shall I say, quote, court, which I'm analogizing to the indictment process. There was a RPX in March of 2016 looked at all of the patents that have gone into PTAB. And they found that right off the bat, 31% of them aren't even instituted at all. And when you look at all of the patents which begin an IPR proceeding, they ended up with a grand total of 43%, where all claims were found unpatentable. And that number, we can debate whether that number is high or low, but it is somewhat on a par with the US Patent Office's statistics when it came to inter partes reexamination, which in 31% of the time found all the claims to be unpatentable. So, at least from my perspective, PTAB indeed is doing the job that it was intended to do. It is a second look at the patent from a patent prosecution point of view. PTAB is not a substitute for litigation, because very often, and depending on what district you're in, you are litigating at the same time that you are doing your IPR. And as far as not being able to freely amend claims during an IPR proceeding is limited. It is a second look at the patent. It is under strict statutory timetables. And I would point out that a patentee who actually does want to amend their claims still always does have reexamination and reissue proceedings to do that.
Thanks, Karen. Lori?
So I guess I'll respond to a few of the different comments that have been made. I do think, so one of the good things that has occurred over the past decade is that we've seen many, many, many studies on patent litigation activity. One of the challenges, though, with that data is that you really have to unpack the data and the definitions to understand what's really going on. So to the comment about, are we seeing a surge in patent litigation that's being driven by NPE activity or troll activity, or however you want to characterize the patent owner, part of that dynamic in terms of high volume filers, if you will, is being driven by the new joinder rules under the AIA. And again, there's empirical data that has looked at that very issue. The fact that you're now required to file multiple suits against multiple defendants, whereas pre-AIA, you could join all those defendants in one suit. That impacts the numbers we see. How you define an NPE obviously has a tremendous impact on the numbers. And one of the, I think, really disturbing trends we've seen over the past decade is that term NPE or troll or PAE sweeping in an increasing universe of innovative firms, whether it's startups, independent inventors, research firms, even universities. And so, this notion that NPEs are driving this massive litigation really is significantly impacted by the universe of entities that you capture within that definition. But there's also a lot of, I think, very rigorous empirical work that shows that historically, over decades, over centuries, the average patent litigation rate has remained remarkably constant. Now, that doesn't suggest that there aren't problems in the system that need to be addressed, but what concerns me is that we have focused so much attention on litigation activity that we have lost sight of this bigger picture that I was alluding to earlier. And what I find interesting and also very disturbing is that when I first started practicing in the intellectual property space about 25 years ago, when you talked about abuse, you automatically understood that concept to mean infringement. You automatically equated abuse with infringement. Today, you equate abuse with enforcement activity. Well, the bottom line is if you make it increasingly difficult to enforce your rights in court, increasingly difficult to survive PTAB proceedings, increasingly difficult to overcome 101 challenges, then you are putting innovative firms, particularly smaller innovative firms, in a position where they can no longer get users of their technology to come to the table and negotiate an agreement to license those technologies. And instead, you are forced to resort to court, which of course many small innovators can't do. And so when you talk to the startup community, the venture capital community, they talk about a dynamic of abuse today that they term efficient infringement, meaning it is no longer a rational business decision for large entities to take a license because they know that at most they're going to be subjected to a court proceeding where ultimately they will likely prevail, and even if they don't prevail, they're looking at a damage award of one kind or another because injunctions are no longer a viable option for most small innovators. So I do think it's important to kind of drill down on where are there inefficiencies in the litigation system or in the PTAB proceeding that need to be addressed. But looking at this larger dynamic of what our patent system is meant to incentivize in terms of investments in innovation and voluntary agreements to take licenses to use protected technology, I think those incentives have been dramatically undermined because of this focus on so-called troll activity over the past 10 years. So going back to your earlier question of what would you not do, I mean, if in my fantasy world, I would completely get rid of the troll narrative. I think it has been tremendously destructive to our patent-based system of innovation. And I would start to focus on, creating appropriate incentives for people to make investments in innovation and for users of patented technology to license those technologies under fair terms. And of course, quality patents is an important part of that equation, but the troll narrative has really, I think, distorted our perspective about what a patent system is meant to accomplish.
Well, just a minute, I'll give you a chance to jump in. I mean, I think as you can see, we don't even really necessarily have agreement on what exactly patent abuse is. So without agreement on that, it can be difficult to formulate good responses, or at least there are different forms of abuse that require different responses. So let me come to you, Ellen, and if you can also address, in particular, I think a good transition point to getting into specific issues. Let's talk about the Patent Office trials and how well they're working and what changes need to be made or shouldn't be made to them. So if you can respond to anything, but if you can drill down on that too.
I was actually going to head into
Perfect.
that without preempting you too much. And so
Terrific.
one thing I want to go back to is the importance of how we think about statistics when it comes to PTAB. First, I think Karen did a fantastic job of laying out what statistics mean within these very complicated procedures. But one thing I often hear, and we often hear, is once instituted, a high number of claims are invalidated. And what I would say to that is, first of all, again, very few claims get to that point, right? We're talking about a minuscule part of the patent world. But beyond that, I would say that means that PTAB is doing its job in two ways. One, its gatekeeping function of only letting very likely invalidation claims go forward. That means we should expect, once they go forward, that that's going to be a pool of highly likely to be invalidated claims. I'd frankly be concerned if they weren't doing their gatekeeping functions, because when the AIA was passed, Congress had a really robust discussion and decision to make on how do we make sure that patentees, which by the way are our companies, are interestingly, we at the Internet Association represent some of the top defendants and top patent filers. So those tend to be some of the same companies in a lot of cases, and I'm sure Karen is in the same position a lot of days. And so when we think about statistics at PTAB and are the trials working, are the gatekeeping functions working? I would say yes, and that the statistics we've talked about actually prove that. The other statistic that we haven't gotten to yet is, I want to say the most recent number is that less than 7% of PTAB decisions are overturned. That's a tiny fraction because they're issuing high quality opinions. And so is it a good thing that they're invalidating claims when we've talked about the importance of patent quality? Yes, because when we talk about driving innovation forward, when you remove things from the public domain that companies can't build upon and innovate on, that's a bad thing. And so I would say yes, the patent trials are working well. They have a robust gatekeeping function. There are estoppel provisions. You have to prove a lot up front. We could kind of go through that list. And the other issue is, are they invalidating low quality patents, which is the ultimate aim of PTAB? And the answer to that is yes.
All right, Hans, you want to take a chance, take a whack at that?
Yes. So the
We gotta have fun
gatekeeping,
here,
we
right?
certainly are going to have fun and are having fun already. Oops. It's true that I think many people characterize PTAB proceedings as a second look at the patent, as a fresh look, right? I think often it's not a second look, it's a third or fourth or fifth look, right? You could have a patent that was examined and granted. It may have been re-examined and affirmed in the patent office, may have gone through reissue, may even have gone through litigation and found not invalid in district court. And still the PTAB will give it a fresh look. From a business perspective, I don't know how much sense that makes, because as a business, at some point you would like the certainty of being able to rely on your patent to invest and build a business around it. And the PTAB is the forum where that certainty truly doesn't exist, right? They are here to give the patent a fresh look. It's not necessarily a second look. So let's see about how that gatekeeper function works, right? It's true, I think statistics can be noodled and twisted in many ways. The latest numbers I saw were institution rates in about the 70% range, right? 70% of petitions that go to the PTAB will have at least one claim instituted and a proceeding on the merits done. If the patent owner doesn't settle before, 1 out of 3 proceedings settled somewhere along the way, presumably against the patent owner, because why would they settle if they could otherwise win? Nonetheless, right? So it's about 70% institution. Once an institution is denied, that's not the end of the matter, right? Somebody else can come back. Sometimes the same petitioner can come back and refile the petition in the PTO and say, oh, I substituted prior art of X against Y using the non-institution decision as a how-to guide. And I will show you the decisions in the PTAB, some of which say, no, we don't want you to do that. Right? That's like a second bite at the apple. And other decisions would say, there's no rule against second bites at the apple. We're much more convinced by your renewed petition, and we'll let it go. the PTAB, out of thousands of decisions on institution, right, and procedural motions and the like, has what, like a dozen precedential decisions? So panels aren't bound to follow what prior panels have done, right? They're all completely free to do as they see fit in any given case. That too, I think, creates uncertainty. Nobody really knows what to expect once your patent goes in there on a petition. The statistics tell you that more likely than not there will be an institution, and if you fight to the end, more likely than not you will lose claims. And if you prevail at the very end, again, that's not the end of it, because somebody else can bring a renewed petition against the same patent on modified grounds. And it might be a proxy of the prior party, right? Because there are very few opportunities to detect proxy dealings or real party and interest problems. So in other words, I think what we need in the PTAB, I think what the PTAB needs in these proceedings is, where did I have it? I have a whole bunch of things that they should do.
Claim construction, evidentiary
yeah,
standards.
I think that the concerns fall into several buckets. What I described was the concern about the lack of finality and predictability of these proceedings, right? So that's one. I think the legal standards, that it be so that more of the protections that apply in district courts should also apply in the PTAB. I think that's important too, because we should not have a proceeding where in a separate form in the patent office, you can go take a patent and systematically expect a different answer than what a district court would give you. I think that is a real systemic problem in the system. We do allow patents to be litigated at the same time in district court and in the PTAB. And we should not allow the two fora to systematically arrive at different conclusions about the validity of the patent, which we currently do, right? Because we do allow the PTAB to apply different standards of proof, different claim construction standards, and other matters. So that, I think, is a real problem. If two decision makers arrive at opposite conclusions about the validity of the patent, right, that effectively gives the challenger two shots on target because they only have to win once. And patents can go up from district court and from the PTAB. The district court not finding it invalid and the PTAB finding it invalid, and the Federal Circuit might look at both and say, you would think one of them's got to be wrong, right? And the Federal Circuit is going to fix that. That's not the case. Because of the different legal standards, the Federal Circuit can say the district court was right and the PTAB was right too. And because the PTAB found the patent to be invalid, that is the end of the matter, right? What is that other than two shots on target for a challenger, right? Business people that I talk to about this find this incomprehensible, that we could have two fora that arrive at different outcomes and both could be correct, right? It can't be right. From a business perspective, it can't be right.
Okay, Karen, you want to take a shot at that, and then Lori maybe respond as well?
I would say that the two forum are asking different questions. The district court litigation in a particular dispute is asking whether the defendants have produced sufficient evidence under the judicial standards, assuming that the Patent Office has done their job correctly. On the other hand, in the PTAB, rather than finding of invalidity, it's a finding of unpatentability, and they are looking at their work again under the same standards that would have applied the first time. So I would say that the two questions that are being asked in each forum are different, and just because they may be proceeding at the same time, again, PTAB is not an alternative to litigation. It is a separate thing from litigation. And I would caution, people to keep that in mind. Obviously, as well, in district court, you have many more avenues to invalidate a patent than you do in PTAB. And as far as multiple attempts to invalidate or find unpatentable a patent in PTAB, the same thing happens in district court. Not necessarily with the same party, but certainly every time a patent is asserted, a new validity challenge can be raised. So in that respect, I don't see any problem with that.
Laura?
Yeah, so having lived through the negotiations over inter-parties review and post-grant review during the AIA debate, and I know Hans did as well, and maybe others did as well, it was quite clear during those negotiations that inter-parties review was intended as an alternative to litigation. Now, you can argue that maybe it's evolved into something different, but when we were sitting around the negotiating table talking to different stakeholders as well as the PTO, the notion was that you would create an alternative, cheaper, more efficient forum in which to adjudicate these validity issues. And there was also a significant amount of time and energy devoted to ensuring that the framework for inter-parties review would guard against serial bites at the apple, not just 2 bites, but multiple bites, as Hans described, and that you would have a meaningful estoppel effect. And in addition, that there would be a meaningful gatekeeper threshold that PTAB would have to adhere to before allowing a petition to move forward. That there would be a meaningful right to amend, because this was meant to be an adjudicative proceeding as opposed to an examination proceeding. Now, fortunately, Qualcomm has not found itself, in the midst of these proceedings, having our patents challenged. But again, just based on the way the proceedings have been applied or interpreted by the PTAB, I would argue that at least those goals as they were defined and reflected in the original statutory language arguably have not been or are not being adhered to today. Now, again, you can argue that it's an evolving process, but it does concern me that all of the fears and concerns that we had about the inter-parties review process, during those negotiations, particularly the threat of serial attacks that we are seeing, come to fruition, becoming a reality today. And again, if you think about what that means in practical terms, in terms of the function that the patent is meant to serve as an incentive to make investments in R&D, I do think there's an argument to be made that PTAB has destabilized the innovation environment, if you will, for patent owners, particularly startups. And I also question, although I haven't looked at the statistics, but having looked in the past at the usage rates of inter-parties review, historically, the vast majority of users of the system have been large companies, not startups. Now, that may not be the case in the most recent stats, but I do question whether you can make the case that somehow PTAB is overwhelmingly benefiting small firms as opposed to large companies.
All right. Well, thanks. I think we've beaten the PTAB horse to death at this point. We've covered patent quality issues. So let's turn to some specifics of litigation now and some changes that have been at least broached and in many cases actually passed in the Innovation Act by the House or the Patent Act by the Senate. So Karen, why don't we start with you? Let's talk about attorney fees. Is it your view that prevailing parties should automatically be entitled to receive attorney fees? In other words, that we should switch the traditional burden as some of these provisions have suggested, or if not, are there other ways that you think fees should be awarded differently from how they're awarded now?
No.
No. That sounds like there's a few double negatives in there. So why don't you unpack that for us?
The answer is no. I do not think that there is any reason to change the entire American jurisprudential system for patents. We've talked about the Supreme Court getting involved in patent cases in recent years, and largely they have come in and said, no, there are no special patent rules, and have they have punched back on the idea that there should be special rules for patents. So that would be my number one answer. I do think that if there were automatic attorney's fees for the prevailing party, that number one raises the immediate question as to who is the prevailing party. If a patentee brings suit on 3 patents and wins on 1, does that make them the prevailing party for their entire attorney's fees and expenses? I think that will lead to ancillary litigation over what the appropriate amount of attorney's fees is. Even in terms of defining a prevailing party, there is a 2014 Federal Circuit case, which I believe is still good law, that says in order to be a prevailing party, you actually have to permanently change the other party's behavior. So in that particular case, the defendant had a finding of no infringement. And the Federal Circuit actually said that the defendant did not prevail because the defendant did not invalidate the patent and therefore did not permanently change the behavior of the other party. And it was a situation in which multiple patents were brought. The patentee did get infringement on one patent and in fact was awarded attorney's fees on that patent. The defendant, on the other hand, with a finding of non-infringement, was not the prevailing party and could not ask for attorney's fees. So that Federal Circuit case is out there, which seems to be rather an uneven playing field in terms of prevailing party. I will note, though, that in the Icon Octane case, after the Supreme Court opinion, it went back to the district court, and Octane, which had received a summary judgment of no infringement, actually was awarded attorney's fees. So I think that to some extent, the term prevailing still has some questions to it, is still being developed. I think there are some contrasting opinions in the court about who can be a prevailing party for attorney's fees. I also wonder whether the potential to be on the hook for attorney's fees may interfere with settlement. If one thinks that one is going to get their attorney's fees, that may weigh in on one side or another in terms of settlement. And also to address one of your points in terms of small inventors, to the extent that we are concerned that they are already having difficulty in enforcing their patents, if they also face being on the hook for the attorney's fees of a large multinational corporation, I think that only makes the problem worse rather than better. Under the current system, I think that the district court is probably in the best position to assess it and make it the initial determination. However, I do think that we do need to be vigilant and we need to keep watch that the attorney's fees decisions, being discretionary, don't end up with a district using attorney's fees to attract patent cases to that district.
Thanks. Hans, how about you? Any thoughts on this one?
I think Karen did a job that I could never do. That was great. Everything you said is reflected in conversations I've had with our members. So BIO is a pretty diverse organization. We have large corporations and we have a lot of small companies. As a trade association, we never really took a position on the fee shifting provisions in the Innovation Act and its predecessor bills, because it might not surprise you, right, that larger corporations among our members were rather more relaxed about the notion of mandatory fee shifting or automatic fee shifting in patent cases, whereas among smaller corporations and smaller companies, it raised maybe the access to justice concerns and the fear of being chilled that you might expect, right? So I think at the end of the day, we never much engaged in this. The one thing that struck me, though, if I think back at the early iterations of the Innovation Act, is how relatively little robust debate was had in Congress about a very simple proposition in the bill. At the time, it just said, oh, the loser in a patent litigation shall pay the winner's attorney's fees. And that was that. Why we didn't much talk about how that's actually going to work, the problems that Karen raised, benchmarking ourselves against other foreign patent systems in industrialized countries where some kind of loser pays rule is actually much more common than the American system.
Right.
Well, so it's not that we don't have experience with these systems, but they're always, I think, much more sophisticated than just a legislative provision saying the loser shall pay the winner.
Sure.
So I think by and large, I'm with you. I think we should let the case law in this space play out. My understanding is that fee awards, I think, are being awarded much more frequently than before Octane Fitness. That's all I have to say about that.
All right, thanks. I guess civility is not dead. We actually can get along and reach agreement. Ellen, I'm going to ask you to give some thoughts about venue. You mentioned it earlier, and maybe you can give some explanation of where you think the venue laws should go, whether by the Supreme Court or by Congress.
Sure. Well, I'll start off by saying, there's still, I think, we talk about the question, is venue a problem? Is action necessary? And I would say that problem is only getting worse, which is interesting because we've talked about other cases and areas of litigation reform where there's been movement in the courts. And interestingly, there could be on venue too, but I would say just a couple of quick statistics. Only 7 years ago, 9% of patent cases were heard in East Texas. That number's about half now of our patent cases. And so that's important because we're seeing a distortion of legal outcomes. We're seeing rules, district rules that are highly favorable to one side and that have really distorted our patent system, where one judge is issuing essentially 1 out of every 5 decisions. And interestingly, that judge for the first time granted attorney's fees, I think just over a year ago, whereas other judges are doing it on a much more frequent basis. So that goes to show you some of the legal distortion that's going on in East Texas. So when we talk about how do we change venue law, I say we look backwards in time, where the fact is that up until 1990, we actually recognized that patent venue was a little bit of a special case. And then we had the VE Holding decision. And so that's what's going up before the Supreme Court now. They granted cert in the TC Heartland case, which is very interesting for others who find venue law terribly interesting out there. And so we'll hopefully have that decision sooner rather than later. This deals with a Delaware case, which is interesting, but it's going to look back at the VE Holding decision, which essentially said, have at it nationwide venue, and was that appropriate? We would argue no. We need to go ahead and go back, pre-VE Holding. The other issue is in Congress, there's been a real shift and a real gearing up of interest in venue post the debates on the Innovation Act and others. And in the House in particular, there was an amendment attached. In the Senate, there's been standalone legislation introduced in the last Congress. And as we gear up here for the next Congress, I think it'll continue. The real question about venue comes down to a simple thing. Is the patent in question connected to the district in question? And we would argue that it should be. Otherwise, you have the problem that is East Texas. And so we need to either legislatively or through the courts, through the TC Heartland decision, reconnect those two issues.
Great. Lori, let me turn to you. You can either respond to that and or talk about software business method patents, just in the interest of time to make sure. Pick or choose, pick both and
easy
divide
segue
your
there.
time. Yeah, exactly.
Let me just say on venue, so for Qualcomm, in principle, I think the notion of having rational venue reform is not at all unacceptable or inappropriate or harmful to the patent system. The concerns that we've had with the legislation that's been tabled in at least the past year is that, to your point about connecting the dots between the activity and the venue, it so swings the pendulum against the patent owner's ability to sue in the venue of your choice, that for Qualcomm, for example, if the patented technology arose from one of our research facilities in North Carolina, for example, we would have difficulty filing suit in our backyard because of the way the tests for venue are structured. And so even though I think there's a lot of merit in what Ellen's saying about having too many cases being brought potentially in one district, we also don't want to make it impossible for innovators, for inventors to sue in their home district. The dynamic you described about forcing, defendants to fly to Texas applies equally to, forcing plaintiffs to fly across country to file suit in some, large companies' home district. So we just have to make sure, I think, that any kind of venue proposal, legislative proposal, is fair and balanced. On software patents, are there particular things you want me to respond to?
I think, well, let me, not necessarily respond, but, just your general thoughts on patent eligibility.
Sure.
The wake of Alice and how to we talk about stabilizing things, whether they are stabilizing or not, how we might try to do so.
Yeah, so I've spoken a little bit about what I consider to be the negative consequences of this kind of overly simplistic, overly pejorative narrative around patent trolls. I think you see some of that same dynamic with respect to software patents, where it's not at all uncommon to read an article in the New York Times or the Wall Street Journal, blaming the patent litigation crisis on software patents. And of course, what that assumes is that there is some well-defined universe of patents that you can characterize or categorize as software patents. And in today's innovative economy, virtually every sector is migrating to technologies that are software implemented. And that's certainly true in the mobile telecommunications sector that we occupy. If you think about semiconductor chips, systems on a chip, highly sophisticated chips that drive smart devices and that will ultimately drive the Internet of Things. The vast majority of that functionality is now being driven by software, whereas 10 or 15 years ago, it might have been implemented through hardware. And there are numerous benefits to that. And it's highly innovative activity. And so to sort of create this pejorative around software patents, to suggest that software patents are inherently low quality or of minimal inventive contribution, I think, is really problematic. The Alice decision, the ambiguity, you're absolutely right, it did not create any sort of categorical rule or preclusive effect with respect to subject matter eligibility for software-related patents, but because of the ambiguity, I think it's created enormous confusion within the patent office. And so you see categories of patents, fields of prior art where the denial rate is, 80%. It's, just really unusually high numbers of rejections, usually high numbers of invalidations. Something that suggests that something is amiss. So I think I know the PTO, just to give credit to the PTO, because I know there's been a lot of focus on the PTAB proceedings. I do think, particularly under Director Lee and also under her the previous director, David Kapos, there's been a tremendous amount of really good, thoughtful work in terms of trying to create greater guidance for examiners around software-related inventions. That became so much more complicated after Alice, and so I guess our hope would be let's allow the dust to settle. Let's allow that work to continue. We've seen in the past some efforts to legislate around software-related patents. I think that would not be a productive step, and let's recognize that we're talking about a vast array of innovative activity that we want to encourage, not stifle through rigid approaches.
Okay, thanks. Let's talk in our remaining amount of time with maybe the one person, certainly the person in the room, and maybe a person in the country who knows the most about a different type of patent, which are design patents. So, Karen, obviously, your company's been at the center of the storm, the eye of the storm over this issue. What can you share either about that experience or about what you would like to see looking forward in that field?
Well, I certainly know more about design patents than I ever thought that I ever would. Just for people who haven't thought about design patents before, and we're going to be talking about design patent damages. Just as in utility under Section 284, a design patentee can choose to assert damages under 284 and may show lost profits if the infringement of the design actually caused a loss of the sale by the patentee. The patentee can get lost profits. The patentee can ask for a reasonable royalty under 284. But for design patents, there's an additional and special design patent damages provision that can be asserted. And that is 289, which was passed in 1877 and really hasn't been talked about very much since that time until this year. And Section 289 says that a design patent holder can receive the total profits from an infringer for the total profits on the article of manufacture to which the patented design has been applied. And that last sentence is basically what went up to the Supreme Court this term. The Federal Circuit, in affirming the district court's decision, essentially said that the article of manufacture is the product as it is sold to consumers, unless parts of it are necessarily sold individually to consumers. We thought that that was a bit excessive, and we took it up to the Supreme Court, and the Supreme Court agreed that the wording of Section 289 says that you get total profits on the article of manufacture, but as a result, you have to figure out what the article of manufacture is that you receive the total profits of. The Supreme Court did not tell us how to perform that test. The case has now been remanded to the Federal Circuit. However, I would say that based on the language of the statute and based on the Supreme Court opinion, the approach to that test is really pretty simple to articulate. And that would be, number one, you look at the design, the actual patented design. You look at the accused product. You figure out what portions of the accused product the design has been applied to. Then step two is you figure out what the profits are on those components or portions. So it's very simple to articulate. Some people have said, well, how would that possibly apply in practice? And so I'd like you to think through some examples with me, and I think that it'll become obvious how that's applied in practice. So assume with me for the moment that you are the design patentee for the entire shark body of the Corvette. And so what you have patented is the entire exterior of the car. You look at the patented design, which is the entire interior. You look at the accused product. The accused product may have taken the overall shark design of the car. Then you have to ask the question, well, how much profit on the car is due to the overall appearance of the shark body of the Corvette? And in that situation, I mean, then it always comes down to an economic analysis, as it always does in any patent damages assessment. But you will have your economic analysis, and you figure out what portion of the product is due to the car body. On the other hand, let us assume for a moment that you are the design patent holder for the cup holder that's in the Corvette. So you take a look at the patented design, and you take a look at the accused car, and the article of manufacture is the cup holder. And then you ask the question, what profits are due to the cup holder in the accused car? And I think that the proportion of profits due to the cup holder in the accused device is probably going to be a lot less than the profits that are attributed to the entire exterior body. And I think that we can all agree that probably the design patent holder who holds the design patent on the entire exterior and the design patent owner who holds the design patent for the cup holder probably are not both entitled to the same result. And I think we could probably agree that they both are not entitled to the entire profits of the accused car. So I think in a nutshell, that's how I would try to articulate the test. And now we will see how the courts actually do so. But I think it may be premature to talk about any kind of congressional involvement until we see how the courts will actually apply.
Great. Oh, thank you. With our last question for everyone, we've managed to go for an hour and a half so far without using any of the words huge or China or sad exclamation mark. But within 3 days, a new administration is taking office, and already a new Congress has been seated. Let's just briefly play the prediction game, if you can, and give any thoughts about one or two things that you think will happen, let's say, over the next term of Congress at least. So we could start with whoever wants to start. Not all at once. Alan, go for it.
I'll jump right in, although I don't know that I have necessarily any predictions that are worth writing down for anyone today. But what I will say is that we've seen a focus on the domestic economy and jobs from the incoming administration and from Congress. And so I think it's important to remember that our innovation economy is really dependent on a strong and sound patent system that returns to its roots, which is promoting the useful sciences, growing innovation. And so, it's our hope, and I think, others as well, that when this new administration moves forward, as the new Congress moves forward, that it takes actions based on that first principle, which is, does this promote innovation? Because that ultimately will grow jobs. I think everyone up here can agree that a strong patent system promotes jobs. It grows our domestic economy. It is a good thing. And so that's very broad and doesn't give, I think, the specifics that maybe folks were hoping for, but that is how we are looking at it.
Thanks. Hans?
I will randomly invoke China.
Excellent.
I think it's going to be good for us to remember, right? As we think about further shaping our patent laws, the direction, should we further weaken our patent laws, for example, at a time when China is strengthening its patent laws, or other countries? I think, to invoke China once again, I believe ITC reform, if it were going to happen, is going to run into a strong counter-narrative at a time when I think there's a renewed focus on U.S. domestic manufacturing and strengthening U.S. competitiveness. Bills that come in proposing to change the remedial powers and the jurisdiction of the ITC, I think will have to answer to the question of, well, what are you doing at a time when the focus really is on domestic manufacturing? Do you want to make it easier to bring in infringing imports or not. So any conversation we're going to have about the ITC, I think we'll have to be carefully calibrated about what do we really want to achieve, right? Is it really just tweaking the domestic industry definition, or is it broader things, and what's the effect going to be vis-a-vis our foreign competitors in other countries? So that's kind of my prediction, because I wanted to invoke
Right.
Asian
you.
manufacturing economies.
Success, mission accomplished. Karen?
As far as what this administration or Congress is going to do, I have no idea. I would like to say one more thing though about the ITC, and that is in the reform package. One of the things that has been talked about in the reform package is what do you do when you actually have the respondents who are actually the ones who are employing people in the United States, whereas the patentees actually are not. Right now, that is not within one of the statutory buckets that is to be considered, and we do think that that is something that should be considered. If 2,000 jobs will be lost in order to benefit one or two people, we think that that should be considered for a statute whose job is to protect our domestic industries and employment.
Lori?
So, with respect to the Trump administration, a few clues. We know, as Hans indicated, that soon-to-be President Trump has focused on the international IP theft issue with respect to China, and I assume other countries as well. So I do think, I agree with Hans, that I think we will have an administration that that looks at the intellectual property issue through more of an international lens, and I think that's a good thing because there is a direct, I think, effect between what we do at home with respect to our intellectual property system and what we can expect globally in terms of our trading partners either respecting or not respecting our intellectual property rights. I think it's, we can also look to the Republican platform that had a very strong statement about the importance of the patent system and intellectual property rights from a constitutional perspective as well as from a jobs perspective. And I think it's also interesting that Donald Trump Jr. published an op-ed a few years ago underscoring the importance of a strong patent system as we think about issues like litigation reform. I think it's also worth noting, however, that regardless of the changes that we will see in the administration, we have a House and Senate that are to a large extent, you more or less have the same actors as with respect to the same last Congress in terms of who's leading the Judiciary Committee in the House and the Senate. So, but what I think has changed and what we can expect in terms of change in the Congress is because of the changes that have taken place at the Supreme Court, in the PTAB and other parts of the system, my sense, and again, I could be proven wrong, is that the committees will gravitate to a narrower version of patent legislation. And of course, you also have the kind of practical reality of those committees having a lot of other work to do in this coming year, with respect to confirmations and of course, all eyes on the Supreme Court. So realistically, I would not expect to see a huge push for very broad patent legislation in the early days, but I do expect to see some form of patent legislation in the coming year.
All right.
Okay.
Thank you all very, very much for your contributions. On behalf of AEI, we're grateful for your taking the time to come and share your thoughts with us today, and we'll keep going and hopefully hear some news at some point over the course of the year. So thank you very much.